today's docket is, again, very different from the last two cases you've heard. This case is an action under the Federal Employer Liabilities Act, which is a kind of analogous to workers' compensation, but it applies to folks that work on the railroads. It's a federal law involving personal injury, but it's often enforced in state courts. And this action arises out of a state court over in Pensacola involving a claimed injury to a railroad worker.
May it please the Court, Your Honor. My name is Newton McCoy. I'm here representing the appellant James A. Metz today. I'd like to reserve 4 minutes for rebuttal. Appreciate the...
Mr. McCoy, I know you're new to this court, and welcome, but we do like you to keep track of your own time, and when the sum-up light comes on, that means that you are actually into your sum-up time, your reserve time.
I'm sorry, I was going by the instructions I was given before court started. So
we never hear those. I don't know what they are, but I see a lot of lawyers when they're... Could you stop the clock for just a moment? A lot of lawyers see the sum-up light come on, and they assume that they're into the close-up part of their first argument, but you're not. You're into your rebuttal time. So I want you to know that.
I appreciate that, Your Honor, and I appreciate being admitted for purposes of this case today. As the court stated, this is an action under the Federal Employers Liability Act. What I'd like to try to address primarily in argument this afternoon is the issue of whether the court properly granted summary judgment in the first instance, and secondarily, whether or not the court properly struck the plaintiff's affidavit on summary judgment. If I don't get to the rehearing, it's not because we want to abandon that issue, but I think the actual summary judgment itself has logical priority and is more central to the disposition of the case. The question really here is one of whether or not, under Florida summary judgment standards, the defendant railroad showed conclusively that there is no genuine issue of fact as to when the statute of limitations accrued in this case under the substantive standard furnished by federal law. So state law applies with respect to the standard for summary judgment, that is, whether or not the defendant must conclusively show that there's an absence of material fact, whether the inferences have to be drawn in favor of the non-moving party, and all the standards that are familiar to the court. With respect to the substantive standard on the statute of limitations, I think the parties are agreed that this is a discovery-type standard used in an occupational exposure kind of case. And the gross test is whether or not the plaintiff knew or should have known of both his injury and of its governing cause. That's both. As it is applied in this particular case, it's a little bit narrower because federal law also says that the plaintiff has a duty of due diligence. That is, he has to act as a reasonable person. The plaintiff can't ignore indications that would make a reasonable person go undertake an investigation to determine what their situation is. And in this particular case, what's relied on and what's important is the plaintiff's deposition and also his medical records and his affidavit. And I want to focus on his deposition and also on the medical records. This case presents, Your Honor, I think, a situation where the deposition and the medical records could be plausibly interpreted to indicate that the symptoms that plaintiff first experienced that he was examined about in deposition were ones that he reasonably regarded as being temporary in nature and that they were going to go away. He had experienced before in his railroad career things that he called little pulls. He testified to this in his deposition, and they went away. And this, he testified, was what these things that occurred, according to his testimony, in January of 2002 were. Now, it's obvious from his testimony also that at some point after that, he was experiencing symptoms that were more severe, and they were constant, and they were disabling. The question, I think, for the court is at what point in time did what he was experiencing reach the point where he had a duty to investigate by going to see a doctor. Now, in this situation, you don't have a case where he waited for a bunch of years in order to go seek medical attention and try to get a diagnosis. Those are a lot of the cases that are cited in the defendant's brief. You're talking about a case that was filed April 5th of 2005. Statute of limitations is 3 years. So your focus is on, did his cause of action accrue?
Let me be clear on this, because this is a discrete injury type of case. Didn't he testify in his depot that on this day in January of 2002 he was doing something or the other and he had this problem, pain that he had never felt before, and from then on he continued to have shoulder, neck pain?
Well, he certainly testified that he had a couple of incidents in January, one involving a door and one involving a handbrake. But the defendant has never treated this as a discrete injury case. They treated it as a cumulative injury case in the court below, and the plaintiff has treated it that way. And our view of his deposition, Your Honor, is that when he experienced these things, he looked at them, in his opinion, as if they were similar to what he had had.
I recognize that, and when I read the briefs the first time, I was assuming this is what we call in workers' comp law in Florida a repetitive injury case. Mm-hmm. It's a more complex statute of limitations issue. But then, as I read through it again, I was thinking, well, no, he said, he almost down to the day and the minute, he said, this is when I got hurt.
Well,
it seems like.
Your Honor, and that's part of what the controversy is about in looking at his deposition. But here's a couple of things about what he testified to. First of all, it's clear that he didn't suffer continuous symptoms because he testified that he had symptoms when he was working. They went away when he was not working. That was his initial situation. They weren't continuous or constant. He had experienced pulls like this before that went away. The kind of job that he did, being a carman, involves heavy labor. And so some pain in your shoulder and some pain in your neck on a temporary basis is regarded as a normal incident of that from time to time. It's not indicative that you have a permanent injury. And I don't think it establishes that what happened to him in January was really the cumulative injury that he went and sought medical care for in April. And certainly there was not such an injury in March of 2002 when he went for a medical examination. And I think the medical examinations are critical. He went to his primary doctor, Dr. Pace, on March 1st of 2002. And remember, our relevant statute date, 3 years before the filing, is April 5, 2002. He goes March 1st to his primary doctor. His primary doctor, Dr. Pace, is giving him a full physical examination, and Dr. Pace documents in his records that he does a full physical examination. And he indicates that he examines the neck, and he makes findings. There are no masses, no tenderness in the neck. He makes an examination of the extremities, and he specifically finds normal range of motion and no tenderness. And at that time, the plaintiff isn't reporting any symptoms to the doctor either. And he's there for a regular physical examination. This is not a situation where the plaintiff just doesn't say something that he knows about when he's at a physical examination. The doctor actually does a physical examination. He makes findings, and those findings contain no positive findings with respect to the neck or the shoulders. Because he's got a concern about tarry stools and cancer of the rectum, he's referred to another doctor, Dr. Orth, that he sees on March 19th of 2002. Dr. Orth, because he's got a new patient, also does and documents in his records a complete physical examination. And he says in his physical exam, he examines general neurologic, neck, and extremities. There are no positive findings in his examination, and he makes a specific note that the neck is supple and without tenderness.
It's an interesting argument, though, and I'm sure you'd agree. That what you're actually telling us to do is to find a conflict of fact by comparing the doctor's notes to your client's own testimony that he hurt himself in January and it got progressively worse for 4 years.
Okay.
Aren't you telling us to do that?
Well, I don't think that it's a contradiction when we lay them side by side, Your Honor, and I understand the point you're trying to make, and that's the defense's point. But let's consider also that this is a plaintiff who testified at the outset that he was not good with dates. When he was asked when he first noticed that he had symptoms with his neck and his shoulders, he said, maybe January 2002. But he said it was a guess, and he said that repeatedly. But that formed the baseline for defense counsel questions thereafter. We've documented in the brief ways that he screwed up other dates. When he's asked, which doctor did you see first? Well, I saw Dr. Cameron. Well, that's not true. He saw Dr. Pace about this first in May of 2002. And at that point, okay, when you're within the 3 years, that's the time when a doctor first makes findings and he first makes complaints. Positive findings of range of motion and pain in the right shoulder. But he didn't see, he saw Dr. Pace in May. He didn't see Dr. Cameron until July. In his deposition, he gets them reversed. He gets them screwed up. He doesn't know the sequence in which he saw doctors and in which he's trying to place things. And you're talking about a 4-month time period at the beginning of January 2002. There's another one that I missed until I was preparing for this argument. He testifies in response to a suggestion by defense counsel that he had his surgery in September 24th of 2002, first surgery. In fact, it was August 24th. And so he's got dates and matters of timing in terms of the sequence screwed up here.
Counsel, I appreciate that, but does any of that really go to his testimony, which maybe I'll be viewed as unfortunate or even mistaken, that he hurt himself in January of 2002, it was different from the pulls he'd had in the past, and it became progressively worse for 4 months?
Well, Your Honor,
it's his inaccuracy as a reporter, because nobody remembers when they went to the doctor.
Okay.
But he did remember the progression of these symptoms.
If you review his testimony, and I've looked at his depo a lot of times, I don't see where you find that he said that what he experienced in January of 2002 was different or more intense than what he experienced before. His testimony, especially if you look around page 120, is that these were similar to the little pulls that he experienced in the past. He did not go to a doctor at that time because he believed that they would resolve themselves with time, as obviously the ones he had before had done. And it's obvious from his testimony that he did not experience these symptoms on a constant basis. You can't tell from his depo at what point in time his symptoms became such that they were different, of a different kind and more intense and more continuous than they had been before. You can tell from his medical records that they were not such on March 1st or March 19th of 2002, because if it was like that, there would have been some positive findings at that time. He was not asked on deposition, when did the symptoms become worse? He was not asked, were they continuous from January of 2002? You cannot tell conclusively from his deposition when these symptoms reached the point that they were different, more intense, and more continuous than they were before.
Why is that different, though, counsel, than someone who in the non-FELA context has an automobile accident, hits her head on the mirror, has a little headache, has had many headaches before, as your client says, has eaten BCs and everything was fine, and then a year later finds out, oh my gosh, she's got some kind of traumatic brain injury.
Okay.
She's still got the same statute of limitations, doesn't she?
Yeah. Well, the theory of the plaintiff's case, and it's not disputed by the defense, is that this is a cumulative injury that has occurred because of the heavy work he has done throughout his railroad career.
Does Dr. Cameron support that?
Well, I don't think we have a letter from Dr. Cameron that says, is it a traumatic injury or is it an injury which is cumulative in nature. It's a shoulder impingement syndrome. which is normally not a traumatic injury. It's something that accumulates over time. Now, he had to have a separated ligament, which might be, but shoulder impingement syndrome is not something that happens with a single injury. And anybody that deals with shoulders all the time knows that. Is that in the record? No, but, there's not really an opinion as to that. And if it were a traumatic injury where he did separate his labrum and all of a sudden have a shoulder impingement problem, at the time that these took place, wouldn't there have been an immediate manifestation of serious symptoms that would have been continuous and would have been detectable on examination in March? I think the more reasonable inference, and here you're talking about what are the inferences from the record, when you keep in mind that he was not asked the question, when did it get this severe, that you couldn't lift your arm or do things? When did it change? Was it continuous? Those things were not asked. The more reasonable inference is that he was not in that condition until after April 5 of 2002, which is 17 days after his negative examination with Dr. Orth, and then May 6th, he's back, and at that time, he has a diametrically different physical examination where there's pain in his right shoulder, tenderness in his right shoulder, and a detectable range of motion, limitation of change in motion. And so, Your Honor, I'd submit that when you lay his deposition down with his records, that you have a situation where he reasonably believed that what he had was a temporary situation in January of 2002, that a reasonable person would not have realized that he had something other than a temporary condition and gone to investigate and seek medical assistance until after April 5 of 2002, when he in fact went on May 6, 2002. That's consistent with his deposition. It's consistent with the records, and I submit it's consistent with the affidavit that he submitted as summary judgment, which for that reason should not have been stricken. I'm completely out of time, Your Honors. I thank you very much. We ask you that you reverse and remand this matter for trial.
Let me mention to you, counsel, we'll allow you a very brief rebuttal. I mean, I guess I said we're pleased to have you in this court. Welcome to North Florida, and if you'd like to take a brief rebuttal, you can certainly have that.
Thank you very much, Your Honor.
May it please the court. I'm Jason Peterson with the law firm of Clark, Partington, Hart, Larry, Bond, and Stackhouse in Pensacola, and I have the pleasure to represent CSX Transportation. The plaintiff in the underlying case was deposed not once but twice. In both depositions, he testified that in January of 2002, during the course and scope of his work, he was participating in Carmen tasks where he was reaching, knocking off a handbrake, closing a boxcar door, and that work resulted in symptomology. It resulted in pain in his neck and his shoulders. He testified that way in both depositions, and in fact, the medical records that were talked about actually support the contention that he was hurt at that time. If you look at Dr. Cameron's record, Dr. Cameron is the orthopedic surgeon that the appellant went to see for his shoulder and neck pain. Dr. Cameron's record said that pain has been ongoing for 6 to 7 months. That correlates and corroborates plaintiff's deposition testimony, which was the basis for the motion for summary judgment. The appellant's deposition testimony is as follows. He was asked, when did you first notice symptoms of a problem in your shoulder and neck area? The answer was around January of 2002, something like that, around that area. When you first began experiencing those symptoms, did you go see a doctor? He said no, because I thought it was just like, a little pull, as counsel referred to, but it kept progressing. Had you had little pulls before over your career? Yes. Oh, yes. I don't know what you call it. I'm not a doctor, so I don't know what you'd call it. But anyway, this, indicating to this shoulder pain, kept getting worse and worse and worse. He said,
you upset with him because he was too stoic?
Well, he testified.
Here you got a guy who's going to take a little pain for the company, And what, you'd rather him be a hypochondriac? You'd rather him run into court and sue you every 5 minutes, every time?
No, Your Honor.
You have a good argument on the record and on the law, but one thing that troubles me about it is it seems to me that this kind of argument really punishes the worker who, for the benefit of the company or the perceived benefit of the company, kind of toughs it out. I mean, you know, here he is. He's not suing you. He's slugging down VCs. Maybe you should give him an award for that. I mean, you know, I don't mean to put it that way, but you know what I'm saying. Is that now we find this working against him? His stoicism and his willing to sort of take one for the team here, not complain, keep on working.
Well, mind you that the FBLA is a situation, it's not like Florida workers' compensation law where there's no fault. In the FBLA, the claimant has to prove that the railroad is at fault for some reason. So to come in and say, beyond 3 years, I've had this cumulative disease, and not with us not knowing exactly what caused it or what the allegation of fault is until beyond 3 years later, it's a little different situation. And I think that's the distinguishing point on Your Honor's question. He said it was getting worse and worse and worse. He said he figured it would ease off, and it did not. And he said he was eating BCs, and it wasn't to no avail. And the problem with
Let me ask you a question I'm sure you all know the answer to, but it's not on this record, but may be important to at least my understanding is, do these fellows have state workers' comp in addition to their FELA rights? They're like seamen. They're totally reliant upon it.
Yes, Your Honor. The Jones Act and the Federal Employers Liability Act is very similar. I don't
Same
know the
standards.
sequencing, but I think one is derived from the other.
But it's the same slight negligence type of standards,
Yes.
specific statute of limitations, and if you're hurt, you need to check into it because you got a statute that's running.
Yes, Your Honor. That's right.
And it's interesting to me to see these United States Supreme Court cases putting an affirmative obligation on the employee to investigate.
That is correct, and
which would be a little too much for me to say, quite frankly.
But it comes out of the Urey and the Kubrick decision, and Freeze talks about that as well as the Johnson case. But the employee, because he is the one that knows and has the symptoms, he does have the affirmative duty to go out and investigate those symptoms and determine if he has an injury. It's not the employer that knows of the symptomology.
Is there any tolling of the statute by reporting the injury to the company, or are you still stuck with the 3-year?
You're stuck with a 3-year statute of limitations. The problem we had with the affidavit was it was in direct conflict with his deposition testimony. To me, it's as clear as the light is red, the light is green. The deposition testimony is the symptoms are continuous, they're ongoing. It's supported by Dr. Cameron's medical record and the statement that the appellant made to Dr. Cameron. And then in the affidavit, what they want to say is, no, the January symptoms were temporary, and they actually say they resolved. They went away. And then in May, this new and different and significant severe pain cropped up such that led him to the doctor. Of course, in Dr. Cameron's records does he mention any kind of pain in May, any kind of new or different pain. What he mentions is 6 to 7 months prior, the symptomology manifested itself and was ongoing.
How long did he continue to work?
Your Honor, I don't know the answer to that question. I think it was up until it was not beyond May. I don't think it was beyond May. And he had surgery in September.
You think he stopped? I mean, I won't hold you to this, and counsel can. But as far as you recall, he stopped working in May, saw Cameron in July, had surgery in September.
That's the best that I remember, Your Honor. Yes. So, really, to sum up, I think Judge Shackelford below correctly struck the affidavit. As this Court knows, this Ellison v. Anderson decision and this Court's decision in Jordan v. Fair does not allow a litigant to create an affidavit that contradicts previous testimony just to create an issue of fact. I am aware that there are other cases where affidavits are allowed if they do explain maybe testimony that was not in the record, or if new or different information is considered to allow someone to change their opinion. That has happened, but that is not the situation we have here. As far as the motion to alter or amend the judgment, really the motion just re-argued the points that was made during the summary judgment hearing. The second affidavit filed by the appellant was really more contradictory than the first affidavit, and the affidavits of the doctors contained really inadmissible hearsay, but I believe the court also found that all of that was just too late and exercised its discretion. So with all that said, I think that this court should affirm Judge Shackelford's decision in all respects. Thank you.
Thank you, Mr. Peterson. And Mr. McCoy, we're happy to give you an hour to sum up and rebut.
How much time?
A minute, an hour. My colleagues are looking at me like I need to.
Just quickly, the FELA is his exclusive remedy. The Jones Act that you referred to is based on the principles of the FELA. He, in fact, worked right up to the day before he had his diagnostic arthroscopy on August 23rd of 2002. He was off of work because obviously he had further surgery after that the next day because he had shoulder impingement syndrome and had to have some resectioning of his labrum. But he worked every day up until that point. With respect to the notation in Dr. Cameron's records, I think you have to understand that at that point, both Dr. Cameron and he are looking back in retrospect. They're in July of 2002. They're looking at his situation where he has positive findings now, and they're kind of looking back trying to parse it out, just as plaintiff was on his deposition. You have to consider, Your Honor, in determining when a reasonable person in his situation would have investigated by seeking medical care. You have to consider that on the basis of how things appeared to him at the time and not how they look in retrospect with 20/20 hindsight.
Your hour is up. Thank you.
Thank you, Your Honor.
Thank you very much. Counsel, thank you both.